Well, it's certainly the best it's ever been in terms of potentially getting a resentencing, and that would likely be a release for the two. The California law changed not long ago, sort of making it possible or at least easier for people to claim that their situation, their psychiatric situation, their victimization situation was not considered at the time they were originally tried. It's basically an out, a leniency for people who might have gotten a lesser sentence today, given our change in attitudes, but years ago might not have. And it's not tailor-made for the Menendez brothers, but it gives them the potential ability to get a resentencing just on that, on top of the fact that apparently, there are ways for the district attorney, considering the fact that they've been such model prisoners, apparently, for the most part, could come in and ask for a resentencing at this point. That would not be as common, but there have been, thanks to the change in the law, literally hundreds of cases that have preceded the Menendez brothers on this new law that have been either released or had their sentences reduced.
Given how globally the issue of domestic violence and sexual abuse has come to the fore, will this influence how the LA District Attorney considers the resentencing request?
Well, I'm not entirely certain that people are correct in their assumption that this wouldn't have had an effect at the time. It did. In the first Menendez trial, they were allowed to put on the description of what the young defendants described as the sexual abuse at the hands of their father and the sort of failure to intervene by the mother. And it had an effect. At the first trial, the jury was given the option of returning a murder or a manslaughter. The manslaughter would have probably resulted, had they been convicted, of them being released 20 years ago. But the jury split 6-6. So half of the jury in the first case was perfectly willing to accept this as a mitigating factor. At the second trial, the judge decided that he had made a mistake in the first trial in allowing that defense to be used. Or mitigation, I should say, because it's technically not a full defense to be used, and didn't let the defense put on any evidence about abuse under the theory that it wasn't really relevant to the way the mitigation law in California was written at the time. So even then, 35 years ago, this had an impact on juries, if they were allowed to hear it.
In your professional opinion, what do you think about how the judge exercised this discretion in the second trial, as you've just spoken about?
I was never crazy about this judge, so I'm not going to let my personal opinions of him as a judge. I thought he was a little pro-prosecution, but then I was a public defender, so what else were I going to think? But he did have a legal basis, which was upheld on appeal, for not allowing the mitigation. And that dealt with the fact that the parents, were shot from behind while they were sitting watching TV, and the mitigation technically is where you honestly but unreasonably fear for your life imminently, that there's an imminent threat of great bodily injury to you. And there was it was not merely unreasonable, it was, according to the judge, in effect, kind of delusional to think that the parents were a threat to them at that moment when they shot. And the law doesn't cover, according to California law, delusional problems the defendants are having unless they're claiming insanity.
So let's bring things back to the present. What's going to be examined in terms of evidence as far as what happens in the courts next?
I'm not entirely certain the evidence that's been brought up in recent times is going to be the most important factor. Perhaps it's a hook on which you can claim that you're going to consider giving them a resentencing, but it's a letter that Erik, the younger of the brothers, who was only 19 at the time, wrote, to someone, allegedly wrote, describing the fact that he was molested, meaning a more contemporary, as we call it in California, a prior consistent statement by the defendants, which wasn't introduced or available apparently at the first trial, and also a claim by someone who was very young during that period, claiming that they were also a male sexually assaulted by the father, which, might have been admissible, might not have been admissible at the time. But it's some evidence somewhat on their side. It's not dramatic evidence in a courtroom that would have definitely changed the verdict of the case. On the other hand, it's enough to say, oh, we're maybe appropriately reconsidering this now. And, they've served 35 years.
Professor Goldman, when we look back at the second trial, how much of an influence did O.J. Simpson's trial and the subsequent acquittal have on the Menendez case that was happening around the same time?
I covered it as a reporter, so I was in the second trial. I didn't go to the first one. But the atmosphere in Los Angeles amongst the DAs was very concerned about the reputation of the DA's office and the DA himself. And that was that they'd lost the O.J. Simpson trial. Then they lost it badly, and they were embarrassed by the district attorney's performance during that trial. They were outgunned by the multi-million-dollar defense team. So I think they really wanted a win, and they wanted a big win. And the Menendez brothers got press, got publicity. The first trial had hung. They really wanted to get a conviction in this case. And they popped the corks when they basically got a conviction. They were very celebratory of this. In fact, it's almost remarkable that they didn't get the death penalty in this case.
So do you believe perhaps that Erik and Lyle Menendez have spent enough time in prison?
Well, it is the American system that in California, they get life without. And you've got to admit the murderers were when just looked at in the cold reading of what they did, horrific. I mean, they not only came up from behind, but the mother was basically crawling away. The boys went out, got some ammunition because they'd used it all, reloaded, came and killed her again. There is a reason why there is life without possibility of parole in California. I think because if there was life with possibility of parole, we'd have gotten more death sentences because of people's fear that these defendants would someday get out. So there's a reason for its existence, and yet they've got a real shot at being resentenced. Perhaps because the DA is running for re-election. Perhaps he's running. The election's in early November. He's down by, double digits to his opponent. This couldn't hurt. And if nothing else, if he loses, it leaves a legacy behind in which he's known as someone who took some pity on these boys who might very well have been the subject of horrific abuse from someone who, in later years, even the district attorney who prosecuted the case said the father was a monster. It just didn't give the sons a right to kill him.
On that point, in recent weeks, the extended Menendez family, those who support Erik and Lyle, as well as Kitty Menendez's sister, say they do believe the boys were abused. How much weight would that have in what the district attorney might decide to do?
I think it has a lot to do with it potentially. Also, a lot of an explanation. The fact that there is a wave of internet interest in the case and has been for a number of years. The belief that they actually were in some respects discriminated against because of their gender. They were men, and the theory of some is that had these been young women, they would have been a whole different ballgame in terms of how the jury or the district attorneys might have approached the case. But these were young men, and the theory is, well, they're men. They can defend themselves, and therefore this isn't as likely to be true as if they'd been a 19 and 21-year-old girl at the time.
Professor Goldman, the Menendez murders have spawned a new generation of fans, many going on TikTok giving their opinions. Has this got to do with the Netflix documentary which you appeared in and the drama series as well? Is that why the case has come to the fore again?
It's interesting that most of their supporters, so many of the supporters, weren't born at the time the crime occurred. And yet it's sort of made its way through new media and become a cause célèbre even before these documentaries came on. And then with the documentaries, that one was on ABC and on obviously Netflix, and the docudrama, it sort of hit a point here where it became more broadly known and understood, and there's sort of an immediate reaction. I don't think the Netflix documentary's been on for more than 10 days or so. So, I mean, a good deal of this movement took place before then. This was sort of the coup de grace to maybe do a little more pushing. Maybe the district attorney will save his election by going along with what seems to be a groundswell of interest. Maybe he doesn't care about the groundswell and just wants to do the right thing before he leaves office.
Well, the next court date is set for 26 November. We will just see what happens then.
I think we're going to hear about it. I think we're going to hear about this before November 26th. We're going to hear about this before Election Day, which is the 5th of November. I would find it hard to believe we don't hear something about it before then.